Hello folks, and welcome back to the final part in this mini-series on banking law. In this part, we're going to be looking at notes surrounding lending, secured lending, bankers' liens, and a little bit more on accommodation bills and accommodation parties. But before doing so, I just want to read through the conclusion on Rich Dave Verner's famous paper back in 2014. Otherwise proved that banks are creators of credit. Again, the kind of things they're getting up to with the accounts in regards to the double entry bookkeeping system, where they're reclassifying accounts payables liabilities as customer deposits, which creates money on account at zero balance every time a loan is issued. That ties in beautifully with how the courts and law are seeing the banker-customer relationship as a special type of debtor-creditor relationship. Okay, whenever we loan funds or give funds to the bank to help be held on deposit, so to speak, it's actually seen as a loan for the banker to do with those funds as he pleases, and that from the eyes of a banker, it's a debt that it owes to the customer, okay, in this special debtor-creditor relationship. So it's not held in trust, it's not held in custody, it's not a bailment. Again, there's no principal-agent relationship there. We're merely seen as an unsecured debtor if that bank was, liquidated. Okay, and so that otherwise, again, reveals the narrative, okay, and it dispels the narrative that's otherwise been spun through economic theory, academia, expert opinion, media, and then more so than regulation and policy decision-making, okay, within the framework of how they're leading everyone in the public to believe that banks are simply deposit-taking institutions that loan out other depositors' money, okay, from either within the bank or outside the bank, or with the central bank under the fractional reserve lending model, okay, which only contributes to 3% of the new money issued in the money supply, whereas 97%, as we found out, is produced through this mechanism of creating money on account at zero balance through the accounting wizardry of reclassifying accounts payable as a customer deposit within this double entry bookkeeping system. Okay, so just want to otherwise read from the horse's mouth, okay, because he encapsulates this very, very perfectly, and it's quite sobering and shocking the extent of what these guys get up to in order to protect the lies. We all know, okay, with the banking especially being the linchpin that controls the securities, the insurance, the law, and the accounting, okay, in order to enslave everyone down here within debt servitude, as we know. So just be careful, obviously, when dealing with these folks, when having this knowledge now, okay, wise as serpents, peaceful as doves, intelligent and honourable on paper, managing your own court of office through the post road mechanics, okay, in order to seek your remedy, whether it be for renegotiating better terms with the banks, applying the technologies of the bills of exchange with the banker's acceptance, using our silent nature to charge these instruments, okay, and providing the bonds that are backed by our security, which is again another account held with the bank on the private side, and also getting ourselves out of any fraudulent contracts, okay, that we might have signed up to where this process had been going on but had not been disclosed, that we can certainly use such papers as exhibits and evidence to really make the bankers sweat. In other words, like I said before, if you even invite the courts to get involved to back your corner if the banks aren't willing to play ball, then you can subpoena the accounts to show that this is exactly what's going on, that this gentleman had found back in 2014, that money is created on account at zero balance, meaning that every time a loan is issued, did the accounts balance as soon as it was issued? Yes. If it zeroed, is there any debt? No. Okay, so that's how people are managing to set off and discharge their mortgages, the loans. But it's up to each and every one of you at the end of the day in order to obtain this knowledge and then put it forth to good use and not abuse it. And just, be careful. Okay, make sure you got all your I's dotted, T's crossed, because even me coming into this information and putting this mini-series together, I've encountered a lot of resistance energetically and spiritually. Okay, and so as we know, throughout history, there's this battle between who gets to control the issuance of money, which is basically control of life force down here as a medium of exchange, okay, to control whole economies. There's been many, many violent assassinations and attempts at knocking those individuals who oppose this central planner's goal of this spider-like centralized system of the Orwellian nightmare have been snuffed out. Okay, so however, if you're doing things diligently and taking your time, being careful, studious in your approach, you should be absolutely fine. But just talking from experience, guys, just be careful, okay? Because this is a very, very important tool for these folks down here in order to implement their control, okay? But papers such as this, Rich Dave Verner, a heaven sent. There's no arguing now. 2 + 2 is always 4. Okay, it's irrefutable, empirical proof that can otherwise blow the whole lid off the smokescreen and mirrors of what they're trying to frame everyone else to believe what banks are when in reality they're not, okay, which even goes into misrepresentation and everything else that goes with that, with what they're getting up to, okay, that you can certainly use now for your benefit to find the remedy and go back to being we, us, and our, the bank, okay, the creators of everything, because we're the only ones that have substance and the ability to bring any real value into the real world, okay, from the resources that are on offer. Right, so with that being said, let's read through this paper, and then we're going to dive over to another paper that joins this paper that kind of looks into a little bit more of the accounting, just to re-emphasize that and hit that home. Okay, and then we'll go over the notes and finish this off, taking out from the book surrounding lending, secured lending, okay, which is it. It's all quite trivial stuff that we've already gone through, but might be some nuggets in there worth considering in regards to seeing it from the lens of a banker, again, which has been very revelationary. So, conclusion, this paper was intended to serve two functions. First, the history of economic thought was examined concerning the question of how banks function. It was found that a long-standing controversy exists that has not been settled empirically. Secondly, empirical tests were conducted to settle the existing and continuing controversies and find out which of the three theories of banking is consistent with the empirical observations. Three theories, but no empirical test. Concerning the first issue, in this paper we identified three distinct hypotheses concerning the role of banks, namely the credit creation theory, the fractional reserve theory, and the financial intermediation theory. It was found that the first theory was dominant until about the mid to late 1920s, featuring leading proponents such as McLeod and Schumpeter. Then the second theory became dominant, under the influence of such economists as Keynes, Crick, Phillips, and Samuelson, until about the early 1960s. From the early 1960s, first under the influence of Keynes and Tobin, and the Journal of Money, Credit and Banking, the financial intermediation theory became dominant. Yet, despite these identifiable areas of predominance, doubts have remained concerning each theory. Most recently, the credit creation theory has experienced a revival, having been championed again in the aftermath of the Japanese banking crisis in the early 1990s, and in the run-up to and aftermath of the European and US financial crises since 2007. However, such works have not yet become influential in the majority of models and theories of the macroeconomy or banking. Okay, thus it had to be concluded that the controversy continues without any scientific attempt having been made at settling it through empirical evidence. So the empirical evidence, credit creation theory supported. The second contribution of this paper has been to report on the first empirical study testing the three main hypotheses. They have been successfully tested in a real-world setting of borrowing from a bank and examining the actual internal bank accounting in an uncontrolled real-world environment. It was examined whether in the process of making money available to the borrower, the bank transfers these funds from other accounts within or outside the bank. In the process of making loaned money available in the borrower's bank account, it was found that the bank did not transfer the money away from other internal or external accounts, resulting in a rejection of both the fractional reserve theory and the financial intermediation theory. Instead, it was found that the bank newly invented the funds by crediting the borrower's account with a deposit, although no such deposit had taken place. This is in line with the claims of the credit creation theory. Thus, it can now be said with confidence for the first time, possibly in the 5,000 years history of banking, that it has been empirically demonstrated that each individual bank creates credit and money out of nothing when it extends what is called a bank loan. The bank does not loan any existing money, but instead creates new money. The money supply is created as fairy dust, produced by the banks out of thin air. The implications are far-reaching. So what is special about banks? Henceforth, economists need not rely on assertions concerning banks. We now know, based on empirical evidence, why banks are different, indeed unique, solving the long-standing puzzle posed by Famer in 1985 and others, and different from both non-bank financial institutions and corporations. It is because they can individually create money out of nothing. So of the implications for economic theory, the empirical evidence shows that of the three theories of banking, it is the one that today has the least influence and that is being belittled in the literature that is supported by the empirical evidence. Furthermore, it is the theory which was widely held at the end of the 19th century and in the first 3 decades of the 20th century. It is sobering to realize that since the 1930s, economists have moved further and further away from the truth instead of coming closer to it. And that certainly also happened in law. If you recollect, under 1933, they replaced securities as substance for collateral for debt. Okay, so they removed the substance. Money backed by gold and silver used to be redeemable negotiable instruments. Now we had non-redeemable negotiable instruments as a result. Securities have now replaced substance as collateral for debt. They then had a colourable currency, which meant that they had to come up with a colourable law system to govern the kind of contracts now and transactions that will be informed when using this colorable currency, which, as we all know, it ended up being codified within the Uniform Commercial Code, disguised as statutory jurisdiction under maritime admiralty law, applied worldwide under this bankruptcy, which is international. Okay, remember UCC Connection, really good book to purchase. My presentation, I went through the keynotes on that to emphasize that point. Okay, that's where everything started to shift for us, where we went from substance-based reality, common law merchant, into this fictional-based colorable law system. Okay, and it seems to be happening in everything. Okay, transhumanist agenda, transgenderist agenda. Okay, bringing us away from source, from substance. Okay, from real life, artificial intelligence. Everything's artificial now. Botox, plastic surgery, technology. Okay, we've got to be very careful, because you can see where a lot of people are being led down that timeline. Okay, that we're going to snap out of it and come back into the organic, substance-based, real timeline. Okay, for all this knowledge. So this happened first via the half-truth of the fractional reserve theory, and then reached the completely false and misleading financial intermediation theory that today is so dominant. Thus, this paper has found evidence that there has been no progress in scientific knowledge in economics, finance, and banking in the 20th century concerning one of the most important fundamental facts for these disciplines. Instead, there has been a regressive development. The known facts were unlearned and have become unknown. This phenomenon deserves further research. For now, it can be mentioned that this process of unlearning the facts of banking could not possibly have taken place without the leading economists of the day having played a significant role in it. The most influential and famous of all 20th century economists, as we saw, was a sequential adherent of all three theories, which is a surprising phenomenon. Moreover, Keynes used his considerable clout to slow scientific analysis of the question whether banks could create money, as he instead engaged in ad hominem attacks on followers of the credit creation theory. Despite his enthusiastic early support for the credit creation theory, Keynes, only 6 years later, was condescending, if not dismissive, of this theory, referring to credit creation only in inverted commas. He was perhaps even more dismissive of supporters of the credit creation theory, who he referred to as being part of the army of heretics and cranks, whose numbers and enthusiasm are extraordinary, and who seem to believe in magic in some kind of utopia. Needless to mention, such rhetoric is not conducive to scientific argument, but this technique was followed by other economists engaged in advancing the fractional reserve and later financial intermediation theories. US Federal Reserve staffer Al Haddaf, 1954, argued similarly during the era when economists worked on getting the fractional reserve theory established, where he stated, "One complication worth discussing concerns the alleged creation of money by bankers. It used to be claimed that bankers could create money by the simple device of opening deposit accounts for their business borrowers. It has since been amply demonstrated that under a fractional reserve system, only the totality of banks can expand deposits to the full reciprocal of the reserve ratio. The individual bank can normally expand to an amount about equal to its primary deposits." The creation of credit by banks had become, in the style of Keynes, an alleged creation, whereby rhetorically it was suggested that such thinking was simplistic and hence could not possibly be true. Tobin used the rhetorical device of abductio ad absurdum to denigrate the credit creation theory by incorrectly suggesting it postulated a widow's cruise, a miraculous vessel producing unlimited amounts of valuable physical goods, and thus its followers were believers in miracles or utopias. This same type of rhetorical denigration of and disengagement with the credit creation theory is also visible in the most recent era. For instance, the New Palgrave Money is an influential 340-page reference work that claims to present a balanced perspective on each topic. Okay, yet the financial intermediation theory is dominant, with a minor representation of the fractional reserve theory. The credit creation theory is not presented at all, even as possibility. But the book does include a chapter entitled Monetary Cranks. In this brief chapter, Keynes' derogatory treatment of supporters of the credit creation theories updated for use in the 1990s with sharpened claws. Ridicule and insult was heaped on several faithful authors that have produced thoughtful analysis of the economy, the monetary system, and the role of banks, such as Nobel laureate Sir Frederick Soddy and C.H. Douglas. Even the seminal influential work by George Frederick Knapp, still favourably cited by Keynes, is identified as being created by a crank. What these apparently wretched authors have in common, and what seems to be their main fault, punishable by being listed in this inauspicious chapter, is that They are adherents of the credit creation theory, but revealingly, their contributions are belittled without it anywhere being stated what their key tenets are, and that their analysis center on the credit creation theory, which itself remains unnamed and is never spelled out. This is not a small feat, and leaves one pondering the possibility that the Etoile et al. Tome was purposely designed to ignore and distract from the rich literature supporting the credit creation theory. Nothing lost, according to the authors, who applaud the development that due to the increased emphasis given to monetary theory by academic economists in recent decades, the monetary cranks have largely disappeared from public debate. And so has the credit creation theory, since the tenets of this theory are never stated in Etoile et al. The chapter on cranks ends up being a litany of ad hominem, denigration, defamation, and character assassination, liberally distributing labels such as cranks, phrasemongers, agitators, populists, and even conspiracy theorists that believe in miracles and engage in wishful thinking, ultimately deceiving their readers by trying to impress their peers with their apparent understanding of economics, even though they had no formal training in the discipline. All that we learn about their actual theories is that somehow these ill-fated authors are opposed to private banks and the money power, without their opposition leading to more sophisticated political analysis. Any reading of the highly sophisticated Soddy quickly reveals such labels as unfounded defamation. To the contrary, the empirical evidence presented in this paper has revealed that the many supporters of the financial intermediation theory and also the adherents of the fractional reserve theory are flat earthers that believe in what is empirically proven to be wrong and which should have been recognizable as being impossible upon deeper consideration of the accounting requirements. Whether the authors in Etoile et al. Did in fact know better is an open question that deserves attention in future research. Certainly the unscientific treatment of the credit creation theory and its supporters by such authors as Keynes, who strongly endorsed the theory only a few years before, authoring tirades against its supporters, or by the authors in Etoile et al., raises the possibility. Implications for government policy. So there are other far-reaching ramifications of the finding that banks individually create credit in money when they do what is called lending money. It is readily seen that this factor is important not only for monetary policy, but also for fiscal policy, and needs to be reflected in economic theories. Policies concerning the avoidance of banking crises or dealing with the aftermath of crisis require a different shape once the reality of the credit creation theory is recognized. They call for a whole new paradigm in monetary economics, macroeconomics, finance, and banking that is based on the reality of banks as creators of the money supply. It has potentially important implications for other disciplines such as accounting, economic and business history, economic geography, politics, sociology, and law. So it's massive. This, like I said, I can't emphasize enough how powerful this piece of knowledge is for us folks. It's a game changer. Like I said, if enough of us get behind this and understand this and start sharing this and start putting the questions and pressure on the banks and the governments, the whole system will change for the better. So we have the implications for bank regulation. The implications are far-reaching for bank regulation and the design of official policies. As mentioned in the introduction, modern national and international banking regulation is predicated on the assumption of the financial intermediation theory is correct, since in fact banks are able to create money out of nothing. Imposing higher capital requirements on banks will not necessarily enable the prevention of boom-bust cycles and banking crises, since even with high capital requirements, banks could still continue to expand the money supply, thereby fueling asset prices, whereby some of this newly created money can be used to increase bank capital. Based on the recognition of this, some economists have argued for more intervention by the central bank in the credit market, for instance via quantitative credit guidance. So monetary reform, the Bank of England's 2014 recent intervention has triggered a public debate about whether the privilege of banks to create money should in fact be revoked. The reality of banks as creators of the money supply does raise the question of the ideal type of monetary system. Much research is needed on this account. Among the many different monetary system designs tried over the past 5,000 years, very few have met the requirement for a fair, effective, accountable, stable, sustainable, and democratic creation and allocation of money. The view of the author, based on more than 23 years of research on this topic, is that it is the safest bet to ensure that the awesome power to create money is returned directly to those to whom it belongs, ordinary people, not technocrats. This can be ensured by the introduction of a network of small, not-for-profit local banks across the nation. Okay, most countries do not currently possess such a system. However, it is at the heart of the successful German economic performance in the past 200 years. It is the very Raiffeisen, Volksbank or Sparkasse banks, the smaller the better, that were helpful in the implementation of this empirical study that should serve as the role model for future policies concerning our monetary system. In addition, one can complement such local public bank money with money issued by local authorities that is accepted to pay local taxes, namely a local public money that has not come about by creating debt, but that is created for services rendered to local authorities or the community. Both forms of local money creation together would create a decentralized and more accountable monetary system that should perform better, based on the empirical evidence from Germany, than the unholy alliance of central banks and big banks, which have done much to create unsustainable asset bubbles and banking crises. Okay, so there we have it, guys. That wraps up, obviously, everything we've covered in this mini-series quite well, and highlights again the extent of the subterfuge being used by these folks to protect that magic process of creating money and controlling economies. Okay, and this is another paper, okay, that otherwise goes into a little bit more in depth the accounting. So I'm just going to skim through this real quick and have a look at this table. So this table shows how accounting conventions handle the granting and dispersing of a loan for different types of firms. Okay, you've got a non-financial corporation, which is here, a non-bank financial institution, which is there, i.e. a stockbroker, and a bank, okay, which is obviously highlighted on the end there. In this and the following tables, only the change in balance sheet items is shown. As can be seen, something is different in the case of the bank. Okay, so when you've got a normal loan being issued by a non-banking institution, you can see the account ledger looks slightly different. Whereas here at the bank, you've got client deposit plus 100. Okay, and so if we go to the next one, this table shows step one of the loan operation, now disaggregated into two steps. Okay, all parties have signed the loan contract, but the borrower has asked out of convenience to delay the disbursement of the loan, which happens in step two. Interestingly, at step one, it is seen that the accounting treatment is the same for all lenders, including the bank. Banks are not different in any way concerning step one. Okay, as you can see, it's all pretty much the same on the accounts. But then step two of the loan operation, disaggregated into two steps, all lenders now disperse the loan and thus discharge their liability. For firms without a banking license, the balance sheet contracts and thus reverts back to the original position. For banks, only the balance sheet remains unchanged in its expanded position. Banks remain stuck in step one. In other words, banks do not discharge the liability. Okay, as you can see, the accounts payable gets redefined and reclassified as a customer deposit. So there's a few notes. While the borrower is given the impression that the bank had transferred money from its capital, reserves or other accounts to the borrower's account, as indeed major theories of banking, the financial intermediation and fractional reserve theories erroneously claim, in reality this is not the case. Neither the bank nor the customer deposited any money, nor were any funds from anywhere outside the bank utilized to make the deposit in the borrower's account. Indeed, there was no depositing of any funds. Okay, and instead of discharging the liability to pay out loans, the banks merely reclassify the liabilities originating from loan contracts from what should be an accounts payable item to customer deposit. Okay, and we have highlighted here the client money rules. Okay, credit institutions and approved banks. We got on this section, the client money rules do not apply to CRD credit institution in relation to deposits within the meaning of the CRD held by that institution. And if a credit institution that holds money as a deposit with itself is subject to the requirement to disclose information before providing services, it should, in compliance with that obligation, notify the client that, one, money held for that client in an account with the credit institution will be held by the firm as banker and not as trustee, okay, or in Scotland as agent. And two, as a result, the money will not be held in accordance with the client money rules. Now it follows then that what enables banks to create credit and hence money is their exemption from the client money rules. Thanks to this exemption, they are allowed to keep customer deposits on their own balance sheet. This means that depositors who deposit their money with a bank are no longer the legal owners of this money. Instead, they're just one of the general creditors of the bank whom it owes money to. Now, banks are not financial intermediaries, but creators of the money supply, whereby the act of creating money is contingent on banks maintaining customer deposit accounts, because the money is invented in the form of fictitious customer deposits that are actually reclassified accounts payable liabilities emanating from loan contracts. Banks could not do this if they did not combine lending and deposit-taking activities. But as we saw, combining these activities is a necessary yet insufficient condition for being able to create credit and money. The necessary and sufficient condition for being able to create credit and money is being exempt from the client money rules. And so we have some implications: revoking the bank's ability to create money through credit creation by simply scrapping banks' exemption from the client money rules in the case of UK regulation. Okay, deleting that particular clause should be sufficient. This is obviously proposing solutions in tackling this. However, apart from the new risks for the public arising from such deregulation, even in this case, banks would maintain their advantage and their monopoly of money creation. If the state maintained the rule that taxes need to be paid in privately created bank money only, today tax payments cannot be made in legal tender, Bank of England notes, but only in bank credit money, which is private company credit created by banks, reclassification of their accounts payable liabilities as imaginary customer deposits. By forcing all taxpayers to acquire bank money in this way, the state effectively transfers sovereignty over money creation to the banks, which is obviously at the heart of this issue that we're in. So we have the Basel rules were doomed to failure since they consider banks as financial intermediaries, when in actual fact, they are the creators of the money supply. So Barclays, this is quite interesting, Barclays raised 5.8 billion in new equity from Gulf sovereign wealth investors, by, it has transpired, lending them the money. As is explained, in his other paper, Barclays implemented a standard loan operation, thus inventing the 5.8 billion deposit lent to the investor. This deposit was then used to purchase the newly issued Barclays shares. Thus, in this case, the bank liability originated from the bank loan to the Gulf investor transmuted from 1, an accounts payable liability, to 2, a customer deposit liability, to finally end up as 3, equity, another category on the liability side of the bank's balance sheet. Effectively, Barclays invented its own capital. This certainly was cheaper for the UK taxpayer than using tax money, as publicly listed companies in general are not allowed to lend money to firms for the purpose of buying their stocks. It was not in conformity with the Companies Act 2006. But regulators were willing to overlook this. So that's very interesting how that was used to prop up their share price during times of crises. So we have the fact that in step 2, the bank is alone among firms, ensuring that the same total impact on assets and liabilities as everyone else at step 1, when the money had not yet been made available to the borrower, demonstrates that the bank did not actually make any money available to the borrower. This means that the bank still has an open accounts payable liability, as it has not in fact discharged its original liability. What banks do is simply reclassify their accounts payable items arising from the act of lending as customer deposits, and the general public, when receiving payment in the form of a transfer of bank deposits, believes that a form of money had been paid into the bank. We have money deposited with the stockbroker is unencumbered by the broker's bankruptcy, since it remains the property of the depositor, held in safe custody as segregated client money, while money deposited with a bank, exempt from the client money rules, is no longer the property of the depositor, and thus in principle goes under together with the bank, is testament to the misleading character of banking terminology. And to wrap it up, we got finally a simple way was found to implement monetary reform should the sovereign, again, we the people, decide to introduce a more transparent way of creating and allocating the money supply. One only needs to revoke the one-sided exemption from the client money rules granted to banks and combine this with client money custody services offered to all banks by HM Treasury. So for each and every one of us that are setting up the so-called advanced treasury pack and utilizing this technology, the bonds, with using the treasury as our bank is one solution. That's otherwise helping to dismantle the system where we're coming back into our own power and not participating as an ignorant debtor on the public side. Narrative of the discourse being spun of what they're having. Many people believe what banks are doing, when in reality, as we know by now, we're experts. It's not the case. There's that 77 and 7. That's interesting. 777 codified at the age of Aquarius. So we've got those 2 papers, guys, that hopefully you folks have read through in your own time. Can banks individually create money out of nothing? theories and empirical evidence, as well as how do banks create money and why can other firms not do the same? An explanation for the coexistence of lending and deposit taking. Very, very powerful to say the least. All right. So it should get a lot of cogs turning in that regards. Right, so to wrap up, we're going to now go through the notes, finish off the notes taken out of the Banking Law in Australia book by Alan Tyree, surrounding secured lending, okay, lending and bankers' liens. So let's get this finished up. Consumer protection. The problem is that the notion of a funds transfer or a transfer of value is a banking concept, not a legal one. In law, an account is merely a record of transactions, and a bank account is one which records indebtedness from the banker to the customer when the account is in credit. Even though the phrase transfer of value may be useful to bankers and financiers, its importation into a legal document will inevitably cause confusion. So you have lending, general principles. In general, lending by the banker to a customer is the subject of a separate and explicit contract, which is more often than not in writing. Loans by a bank will always be by means of establishing an account rather than handing over banknotes. In a number of cases, a debtor has argued that there is no loan because the bank has merely made a book entry. Okay, it is sometimes argued that the book entry is creating money and thus violates the Constitution. See, for example, Bendigo and Adelaide Bank versus Graham, upheld on appeal in 2020. We have the National Australia Bank versus Walter. Okay, also argued that the loan was credit creation and fractional reserve banking. Okay, see also National Australia Bank versus McFarlane, where the mortgager argued that the mortgage was invalid unless the lender hands over bullion, banknotes or coin. Then we have in each of these cases, the court has accepted that the argument ignores the realities of modern commerce. It is not only legal tender, that is money. The cases also include arguments based on a misguided notion of bills of exchange and promissory notes. I mean, guys, you can certainly look up the cases and see where they were deficient, okay, in being able to, achieve that remedy when comparing it to the knowledge that we know based off of, Richard A. Werner's work. So interesting how the author with the cases reference still avoids the reality of what the banks are doing. This is just probably due to a lack of evidence and education, especially with these cases where people were heading down the right paths, but probably lack the full understanding of what banks are getting up to and then how to present that argument to gain the remedy. I wonder if Richard A. Werner's empirical study is brought up in court or when questioning whether valuable consideration, or better yet, the risk was in a loan contract with the bank, what the outcome would be, as the evidence is insurmountable thanks to his paper in 2014 that proves beyond a shadow of a doubt that banks create credit from nothing when issuing a loan. Okay, meaning the books did balance, showing zero debt at the moment the loan was issued. That study should be enough for anyone to prove a lack of consideration and risk on the part of the bank when the creditors are created off the back of a loan you take out. It also evidences misrepresentation in the form of bank advertisements, including the regulation and economic theory surrounding this practice, as banks are not deposit-taking institutions and they do not loan out other depositors' funds. Now, there's good presentation by Bill Turner, okay, bank practices in simple language. That will give you some more ideas for folks if you're, on a death grip, serving a fraudulent loan contract. Other questions that you might want to consider when formulating, again, your conditional acceptance and backing the bankers into a corner when achieving your remedy of setting off and discharging the mortgage, okay, and revealing the frauds and the lack of full disclosure and everything else that goes with it. Okay, and one particular one that's, again, another one that's very powerful is obviously at the time the loan was issued, did the books balance? Of course it did. Okay, and these are the ones that you can consider. And there's one here, who holds the original loan agreement that I signed? Because we know obviously once the promissory note has been received with your sign of nature and they've done what they've done with creating money on account at zero balance, they then package those promissory notes, bundle them up, okay, and then securitize them and then issue them onto the markets and sell them on at a discount. Okay, so they wouldn't be the original holder of the note. It'd be some other person, okay, who's obviously bought that note through one of these intermediaries, brokers or hedge funds, right, mutual funds, who's standing to receive the obligation of the principal plus interest repayments that the bank merely acts as a pass-through entity for. Okay, so you can read through that in your own time, and I recommend going to watch that as well, specifically for people who have taken out mortgages, right? That will help aid you when now utilizing this powerful knowledge with Werner's papers and our knowledge now of the bank and customer relationship, what's actually happening through the eyes of the law with these institutions, as compared to what's been advertised, right? So secured and unsecured. A secured loan requires that the borrower provides the lender with an interest in some property. In the event of default, the lender may seek to recover the amount due from the property. The insolvency of the borrower generally does not impair the interest in property. A secured loan might be recoverable even when the borrower is unable, as distinct from unwilling to pay. So we've got commercial and financial bills. A bill of exchange allows the bank to lend its credit instead of advancing funds directly to the customer. A bill which bears the acceptance or the endorsement of a bank is known as a bank bill and is obviously valuable on the bill market. In establishing a bill line, the bank will agree to accept bills drawn on it by the customer up to the limit agreed upon. The customer may then discount the bank bill on the commercial market, and the bank charges an acceptance fee which, together with the discount for the face value of the bill, represents the interest which the customer will pay for the funds. So a related arrangement is a discount line in which the bank agrees to discount bills drawn by the customer. As far as the customer is concerned, this is very much like a loan in that he or she receives money directly from the bank and is obliged to repay funds to the bank at a particular time. From the banker's point of view, however, the bill provides a hedge against liquidity pressures since the banker reserves the right to discount the bill at any time. Commercial bills are usually for periods of 90 or 180 days. Since the customer is likely to need funds for a long period of time, the line of credit usually provides that the bills may be rolled over. That is, the customer will draw new bills at the time of maturity of the original set. In this way, the borrower is assured of longer-term finance, although the interest rate will vary with the market. So accommodation parties, the use of a bill of exchange in the lending transactions may lead to certain legal problems. When the bank accepts a bill, it is the primary debtor on the bill. However, the commercial reality of the transaction is that the customer borrower is the primary debtor. The Bills of Exchange Act 1909 reflects this economic distinction in Section 33 through the concept of an accommodation party. Okay, Section 33 provides that an accommodation party to a bill is a person who has signed a bill as drawer, acceptor, or endorser without receiving value thereof, and for the purpose of lending his name to some other party. The Bills of Exchange Act then makes certain provisions which give effect to the agreement between the party accommodated and the accommodation party. Thus, an accommodation party is liable on the bill to a holder for value and is immaterial whether the holder knew that the other party was an accommodation party when he or she took the bill. So although the heading of the section refers to accommodation bill or party, the section itself defines only accommodation party. Okay, the term accommodation bill is usually used to refer to a bill where the acceptor is an accommodation party, but commercial usage does not appear to have any inflexible rule. So the matter is not one of mere terminology, for Section 64 implements the remaining legal framework of the commercial function of the accommodation facility. It provides that where an accommodation bill is paid in due course by the party accommodated, the bill is discharged. Remember, we went through that in the Bills of Exchange Act and how we can utilize when signing by accommodation, right, our straw man or name of the father surname linked to the prepaid account birth registration number. So is the bank an accommodation party within the meaning of the Bills of Exchange Act when it accepts a bill under an acceptance facility agreement, or does it accept the bill without receiving value thereof when it receives the acceptance? Ellinger argues that the acceptance fee is not consideration for the acceptance of each individual bill. As evidence, he notes that the fee would be payable even if no bills were ever accepted. So the argument is only partially convincing, for it is also clear that there would be no acceptance if the fee were not paid, so that the fee must be at least partly the consideration for the acceptance of each bill. Further, Section 33 of the Bills of Exchange Act does not refer to the value being directly related to the instrument, but rather to the acceptance. Okay, the High Court in Coles Wire Finance Limited versus Federal Commissioner of Taxation accepted that bank charges were not valued for the purposes of determining if a bill was an accommodation bill. Okay, so we have case law on the subject is not conclusive. Okay, in this particular case, the New Zealand Supreme Court held that the bills in question were not accommodation bills, but the fee payable was more complex than a simple acceptance fee. Ellinger argues that this distinguishes the case, and in this case are referred to as accommodation bills, but it's clear that the term was being used in its commercial rather than its legal sense. So in spite of these problems, to hold that bills drawn under an acceptance facility are not accommodation bills leads to strange commercial results. The drawer of the bill is obliged to put the acceptor into funds to meet the bill. If instead he or she pays the bill directly to the holder, can it be imagined that the acceptor may then be sued for the amount on the bill? So there may be a way around the problem. Okay, in this case, Cook versus Lister, Wills LG said, in each case with reference to bills of exchange, if a question arises who is the principal debtor, prima facie the acceptor is the principal debtor. Okay, and then in order, the drawer and the endorsers, as their names appear upon the bill. But the court is bound to test the evidence to show that in any case, the person who is not the principal debtor in the face of the bill is, in fact, the principal debtor. And if he is the principal, he is the agent to pay all those debtors subordinate to him, including the acceptor. So Cook versus Lister was decided before the Bills of Exchange Act, but the logic of the argument remains intact. If that is so, then the commercial accommodation bill would be discharged by payment by the drawer, even if the bill is not a legal accommodation bill within the meaning of the Bills of Exchange Act. So we've got some Google definitions of accommodation bill is a bill of exchange signed by a person, the accommodation party, who acts as a guarantor. So the accommodation party is liable for the bill should the acceptor fail to pay at maturity. We have, for example, let us suppose A is in need of money. He approaches his friend B and asks him to give him a loan for $5,000. B also shows his inability but agrees that he will accept a bill of exchange. A draws a bill on B, which he accepts at 3 months. A discounts the bill with his bank and gets the money. Okay, so got securities. A customer who wishes to borrow money from a bank using the mechanism of a bill line may be required to give security. Okay, problems have sometimes arisen where a party to the bill has been forced to pay and the party holding the security for payment is either not liable on the bill or has become insolvent. Okay, the person who has been forced to pay may argue that he or she is entitled to the security, that in some sense the security runs with the bill. So an endorser was forced to pay. So in this particular case, okay, an endorser was forced to pay on an accommodation bill where the drawer and the acceptor were both insolvent. The drawer had given securities to the acceptor to guarantee the payment of the bill. These were not securities held by the acceptor for the general liability of the drawer, but rather securities specifically appropriated to cover the acceptor's liability on the bill. The court held that the endorser was entitled to be subrogated to the securities. Okay, and so signing by accommodation where someone lends his or her name and credit to an instrument is slightly different to a conventional bill when issued by a creditor to a debtor. In this instance, both the drawer and the acceptor of an accommodation bill can be the debtor in this instance, who often lends something of security to guarantee the bill, upon which the drawer/principal debtor can sell at a discount to get the cash. Okay, the bill is then circulated and negotiated as cash when endorsed by the holder until such time they make a presentment to collect on the bill by the principal debtor. If the drawer defaults, then the person who signs by accommodation, the acceptor, is then liable on the bill. So if both defaulted, as was the scenario in the case above, then the endorser has the right to subrogate for the securities, okay, which puts the endorser in a position to claim the rights and defenses of the creditor on the bill to liquidate the securities or seize them/take them. So performance bonds, the banker will treat the issuance of a performance bond in much the same way as a loan. The customer must promise to put the banker in funds should the bond be drawn up, and the banker will need to assess the ability of the customer to fulfill this promise. The banker will take appropriate securities to guard against the possibility of insolvency. So when we issue our bonds to the Treasury or whomever, and when we sign a surety on behalf of the straw man and name of the father, these two entities become our surety, whose security is the birth certificate. Okay, and that birth certificate is like a blank check that is linked to an unlimited exemption account. Flogging a dead horse, I know, guys. Okay, but it's good to re-emphasize these points. So when we print our bonds on the back of the birth certificate or join with it, for whatever purpose, we are offering two sureties, as well as security in the form of an unlimited exemption account that will fund the bond and any claims made as stipulated in the bond order. So we have letters of comfort. So although the term is not one with a fixed legal meaning, a letter of comfort is some form of assurance from a third party, usually a parent company, to a lender, which represents that some fact is true, that the third party is aware of the loan, or that the third party agrees to a certain conduct in the future. So it is also necessary to consider the distinction between an undertaking as to the future and a mere statement of present intention. Statements of present intention need merely be true at the time that they are made, but an undertaking as to the future will be interpreted as a promise. So companies are a separate legal entity, and all dealings with it are necessarily through agents of the company. This may raise problems of authority for the lending banker. There are many companies which are virtually alter egos of one individual or a few individuals. Consequently, a loan to such a company will usually require guarantees and or securities from the individuals behind the company. Okay, so as we know, even a straw man is a company, needs an agent. Ask the real living individual, what's the best security we can utilize? A birth certificate, which is what? Evidence of what? And back to my what? Our prepaid and limited exemption account on the private side. So secured lending, a security is a lender's interest in property that may only be realized under certain circumstances, usually a default in repayment. The security may arise either by agreement between the parties or by operation of law. We have security interest, may be legal or equitable. Okay, the difference is purely operational. A legal interest is one prior to the enactment of the Judicature Act 1873 in the UK, recognised by a court of common law. An equitable interest is one within the same time frame, recognised only by a court of equity. So common law is the unwritten law based on custom or court decision, as distinct from statute law. Okay, equity is a body of rules developed in the Court of Chancery in England and followed in other common law countries, serving to supplement and remedy the limitations of the common law. So apart from special interests created by statute, there are only three types of consensual security interest known to our law. One, the pledge, okay, the actual constructive delivery of possession of an asset, made with the intention that the creditor retain possession until discharge of the obligation. Two, the mortgage, the transfer of ownership of the asset upon the express or implied condition that the debtor regains ownership upon discharge of the obligation. And three, the charge, known only to equity. A charge transfers neither ownership nor possession, but on default allows the creditor to satisfy the obligation out of the proceeds of the property. So a security interest may be in real property, in chattels, and in choses in action. In order to determine that the seller was the true owner, it was necessary to establish that the previous seller was the true owner, and so on, right back to the original Crown grant. Okay, this is in relation to the land. Again, the Crown granting permission to use the land, and for that use, there is a tax that has to be paid when transferring real estate, as it is all royal estate being leased by the Crown, okay, as well as with rates from the local government councils, which is all prepaid anyway, as we all know. So old style mortgages in the deed system, a mortgage of land took the form of conveyance of the land coupled with the contractual promise that the lender, the new owner of the land, could convey it back to the borrower when the borrower complied with the terms of repayment of the loan. So we have the torrent system here in Australia of land registration. The deficiencies of the deed system led to the introduction into Australia of the torrent system of land registration. The following description focuses on freehold property. Certain property held on a lesser tenure from the Crown is also included in the torrent system. The touchstone of the torrent system is indefeasibility of title. Okay, registration as the registered proprietor is conclusive evidence of ownership. It is not necessary for the registered owner to prove that previous transfers were valid. So have a certificate of title attaches to each parcel of land registered under the torrent system. The local titles office retains the original of the certificate. Okay, the registered owner or the first registered mortgage obtains a copy of the certificate. The copy of the certificate is important and can play a role, similar in some respects to the old deed of title. Thereof, most major dealings with the land must be registered with the appropriate titles office. Okay, notations on the original certificate of title record these dealings in a public register. Consequently, an inspection of the public register will reveal details about all previous dealings with the land, as well as any existing outstanding interest in the land which require registration. This public register is considered so important that everyone is deemed in law to know the contents of it. So electronic conveyancing, when dealing with status correction too, obviously the land registry, that's where they put the lien against the movable dirt, which is us, okay, the real estate, that's really us, okay, that this is all connected into as well. So electronic conveyancing, if the system of registration and notation and certificates of title seem archaic in the age of the internet, it is because they are. Electronic conveyancing is now provided by electronic lodgement network operators. We have the electronic payment permits, electronic title transfers, lodging and withdrawal of caveats, settlement by electronic transfer of funds, and in general, most of the legal paperwork associated with property dealings. Electronic certificates of title replace paper certificates where the system is available. So we have a mortgage has effect as a security, but does not operate as a transfer of land. A registered mortgage is more in the nature of a charge than a mortgage, although, of course, the interest is legal rather than equitable. We have, under the old system of land transfer, a deposit of title deeds with the lender created an equitable mortgage. The torrents priority by registration. The importance of the register diminishes the difference between legal and equitable registered interest, since registration constitutes notice to the world. Okay, there can be no such thing as a later legal interest created without notice of a prior equitable one. So in effect, then time of registration determines the priority of interest. So registered interest will gain priority over an unregistered one, even if registered with notice of the existence of the unregistered interest. Normal priority rules apply if both interests are unregistered. So we have secured lending, personal property. Modern commercial borrowers are able to offer substantial security over chattels and over choses in action. The introduction of the Personal Property Securities Act reformed the law relating to securities over personal property. So the Act does not create securities, but does regulate their enforcement and, most importantly, prioritize among competing interests. Different jurisdictions all over the common law world introduced legislation to allow the creation of transfer of interest in chattels without the need to also transfer the possession of the chattels. So a hire purchase agreement is a contract following a person to hire a chattel with an option to purchase after a fixed period of time. So I've reformed. So most proposals were used on the US Article 9 of the UCC. Okay, Article 9 had some valuable concepts, in particular, 1, attachment, so the time at which the security interest comes into being, and 2, perfection, okay, which establishes a time for priority purposes and protects against third-party purchases. We have Article 9 attempts to treat all security interests equally, looking to function rather than form. This was a dramatic change from the previous law. Until the reform, the law recognized only 4 types of security: charge, the mortgage, pledge, and liens. Parties were free to structure their transactions as they wished, and they often wished to ensure that the interest of the lender was not one of the existing security interests. So the best security interest of all was to hold title to the chattel. Okay, as a result, transactions were artificially structured to ensure that the lender held title to the chattel. The hire purchase agreement is one such arrangement. The legal mortgage also gives legal title to the owner, to the lender, but the legal mortgage was a bill of sale and so required registration. So very, interesting how the best security interest of all was to hold legal title to the chattel. Okay, under this bankruptcy, as we know worldwide, this is certainly the case and is being practiced where possession is 9/10 of the law, with title being the other 10th, okay, and transactions being artificially structured, which take away substance from the money used to transact in commerce, i.e. cuttable currency in the form of fiat debt-based notes, inducing now cuttable transactions and contracts, which required a cuttable law system to govern them in order for the lender, the international creditors, central banks to retain legal title. Okay, and you've got lock, stock, and 2 smoking barrels. That is how you control the world, Illuminati style. It's all coming to an end very soon, I'm sure of it. Got to keep the faith. So the Personal Property Securities Act 2009 has changed the old rules, sometimes with surprising results. One of the most surprising to many business people is that ownership is no longer sufficient to overcome all other interests. Okay, the Act provides that in certain circumstances, ownership may be subordinate to a security interest. Each of the principles of the Act has exceptions, and defining the exceptions proved to be a difficult obstacle to reform agreements. Okay, New Zealand implemented the Personal Property Security Act based on Article 9. Likewise, Canada did. Okay, Australia finally followed in 2009 with the Personal Property Securities Act. Okay, from October 2011, this act replaces the varied state acts governing securities over personal property. The Australian Act is based on New Zealand, Canada, and US legislation, as well as work done by the United Nations Commission on International Trade Law and the International Institute for the Unification of Private Law, okay, which, as we all know, is UNIDROIT, which is located in Rome. So collateral means any personal property to which a security interest is attached. Personal property includes almost any property interest other than land. Land includes all estates and interests in land, but excludes fixtures. License is defined in Section 10 to be a transferable right. And then security interest is defined as an interest in relation to personal property provided for by a transaction that in substance secured payment or performance of an obligation without regard to the form of the transaction or the identity of the person who has title to the property. So creating the security is, the security agreement, most important document in this current system of law they have us under with this debtor-creditor relationship. A security agreement is any agreement or act by which a security interest is created. It may also refer to writing evidencing the agreement or act. Okay, see the PPSA. Thus, for example, the deposit of title documents would itself be a security agreement since the act creates an equitable mortgage over the goods. The essence of a chattel mortgage is that the debtor owns the goods and transfers title to the creditor, subject to a right of redemption. Okay, attachment. The security interest becomes enforceable against the grantor. That's what they call the debtor here in Australia. At the time when the interest attaches to the collateral, attachment is thus an important concept in the Act. And we have Section 19 provides that an interest attaches when the grantor has rights in the collateral or the power to transfer rights to the secured party, and either value is given for the security interest or the grantor does an act by which the security interest arises. Okay, signing the security agreement, for example. Now, Section 53 provides that the rights of the secured party are subrogated to the rights of the person who transferred the interest and passed to perfection, subject to exceptions and special rules. Section 21 of the personal PPSA provides that a security interest is perfected, okay, by registration, possession, okay, by the secured party, control of certain types of chattel by the secured party, and temporary perfection. Okay, security interests may be perfected by other means, so not all perfected instruments will appear on the register. There is no need to file copies of the security agreement. Okay, so registration of a security interest in personal property may be made before a security agreement is made and before the security interest attaches to the property. And then atonement is a formal acknowledgement that the goods are being held on behalf of another party. And Section 22(1)(b) provides that the security interest is perfected if the bailee attorns to the secured party, since in that case the bailee holds the goods in the name of the secured party and the interest is perfected by possession. So the security interest may also be perfected if the bailee issued a document of title to the goods in the name of the secured party. A security interest in the goods is also perfected if the bailee issued a negotiable document of title to the goods and the secured party has perfected interest in the document. Okay, this is important in the context of bills of lading and documentary credits. So we have purchase money security interest, a PMSI, is defined by Section 14 and is, in effect, a security interest in collateral to the extent that it secures the amount advanced for the newly acquired collateral. Okay, so we've got lending guarantees. Guarantee is a conditional promise of the form. If the principal debtor defaults, then I will honour the obligation. A contract of indemnity is an unconditional promise by one person to another that the obligation of a third party will be discharged. It is a promise of the form, if you lend 1,000 to A, then I will see that you are paid. Okay, guarantee, on the other hand, is a conditional promise of the form. If you lend 1,000 to A and A does not pay you, then I shall. So if the agreement is a guarantee, then the guarantor also escapes liability, for there is no liability on the guarantor if the principal debtor has met his or her obligation. So if the agreement is an indemnity, however, then the indemnifier remains liable for the liability under an indemnity is a primary liability which exists independently of the liability of the principal debtor. Okay, so if we want to indemnify ourselves, the living man / woman, as well as our straw man, okay, in commerce, for anything and everything we do, then it makes sense to have the name of the father act as surety to that which binds the crown to cough up whenever the claim arises. Okay, and that's obviously taken from Bill Turner's suggestion and obviously doing the forensics on the forms and showing that there are at least three entities in this Holy Trinity, name of the Father, the Holy Ghost, straw man, and the Son, the living son or daughter, in that regard, that we can bind the crown through the name of the Father, which is the Vatican, which is these guys, to step in as surety in order to indemnify us for whatever it is we do with these negotiable instruments, okay, but none more so than obviously the indemnity bonds, set-off bonds, etc. So the courts will look to the substance of a promise to determine if it is a contract, a guarantee, or one of indemnity. So the words used are not in themselves conclusive as to the nature of the contract, and it's possible to draft documents which are both guarantees and indemnities. So of rights to securities, if the guarantor pays off the entirety of the debt, then he or she is entitled to be subrogated to all the rights previously enjoyed by the principal creditor in respect to the debt. Some relationships are characterized by a dominant and a weaker party. Okay, you've got the parent or guardian and child, solicitor and client, trustee and beneficiary. What is the difference between indemnified and surety? So the liability of the indemnifier is primary, The liability in a contract of indemnity is contingent in the sense that it may or may not arise. The liability of the surety is a secondary one. His obligation to pay arises only when the principal debtor defaults. Okay, but that's in the eyes of the law, surety is almost seen as the same as an indemnifier. Okay, so this is, I think, just taken off Google. So keep that in mind. Surety and indemnifier are pretty much one and the same. And that's obviously what they hope we step up as an agent for, as surety, okay, indemnifier for the straw man whenever he's getting in trouble, so-called, within this fictional plane of two-dimensional paper, contracts and procedures and arenas. So unconscionable conduct legislation. Australian consumer law, Section 18 provides that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive, or is likely to mislead or deceive. I wonder where the banks fall under that bracket in regards to the things they're getting up to, as we know, if we found out. So bankers' lien and freezing orders. Freezing orders are also known as Mariva orders or Mariva injunctions. Okay, so power of sale. The banker's lien carries with it the power of sale and recoupment from the proceeds. This is such an unusual characteristic of liens that the banker's lien has been described as in the nature of an implied pledge. So this power of sale was not particularly important in the case of negotiable instruments, since the banker would deal with these as holder or as agent for collection. But when the securities consist of other documents, the power of sale may become an important method of realization. So the lien does not attach to the credit balance in a current account, since that sum is a debt owed by the banker to the customer. Note that the Personal Property Securities Act allows a bank to take a security interest in an account held with it. And we have documentary credits, insurance documents. So an insurance policy is a document which actually embodies the contract between the insurer and the insured. The Marine Insurance Act 1909 governs policies of marine insurance. Okay, the benefits of a marine insurance policy are transferable. An essential feature in the operation of SIF contracts. There are two documentation problems related to insurance. The first is that when a policy of insurance is first negotiated, it will usually be not with an insurer directly, but with the broker. The broker will issue a cover note, which is legally binding between the insurer and the initial insured. A cover note does not contain the terms of the contract of insurance and is not transferable. Okay. However, because of the delay which may occur between the issue of the cover note and the policy, sellers have sometimes wished to tender the cover note as the insurance documentation. If the credit does not explicitly authorize this, then the cover note issued by a broker is not an acceptable insurance document. Okay, and that wraps up, guys, this mini-series on banking. Hope it's been very enlightening for you folks, as it has been for me. And you've got a lot now to chew over and consider when implementing, your remedies and strategies that you want to formulate in order to access your remedy. And highly advise and recommend, obviously, reading the papers, going back over this multiple times, and also going through Winston Strout's Kelowna series that I've uploaded also on my YouTube channel in order to re-emphasize some of these important points, none more so to do with the bonds and that kind of technology with the accepting for value, and how we can now start acting as we, us, and our, as the banks who create all the credit. Okay, and start having a little bit of fun and making these guys sweat in power in regards to the banks, okay, and the governments, especially when utilizing the technologies now and the kind of assets and securities we have available to us. Okay, so wish you all the best of luck out there, guys. And as always, stay safe, stay sovereign, do your research and due diligence, wise as serpents, peaceful as doves, and wish you all the best on your journey and best of luck. All right, ciao for now.